to get in to the web. Hello, everyone. Thank you so much for attending today's webinar. My name is Attorney Whaley, and today we are going to talk about self-petitioning green cards. We're just going to give people a few more minutes to get into the webinar, and then we'll start shortly. Thank you so much for everyone attending. We're just taking a few more minutes to allow everybody to get into the webinar, and then we'll be starting soon. All right. Thank you so much for attending today's webinar. My name is Senior Attorney Hannah Whaley, and today we are going to talk all about self-petitioning green cards, how you can get there, and various ways that you're able to get yourself to a self-petitioning green card, depending on what you're starting off with, whether it's a non-immigrant visa or another form of visa. But I'm excited that all of you guys are here, and I hope that this webinar is extremely insightful and that it provides you some hope. So the first thing we'll go over is everything that we'll be discussing. The first thing we will be talking about self-petitioning employment-based green cards and their requirements, the application process, the strategies for a strong self-petition, pathways for F1 students, eligibility for employment-based green cards for TPS and DACA holders, and pathways for self-petitions via other non-immigrant visa categories. So the first question is, what is a self-petition? And many people are unfamiliar with this category and way to get a green card, but all that it means is that you are not using an employer sponsorship or a job offer. Specifically, when you self-petition, you are applying for an immigrant benefit on your own behalf. And that is one of the biggest benefits of going through the green card process as a self-petitioner. Now, why should you self-petition? There are three big reasons that I always push self-petitioning. The first one is faster processing and shorter process. And this is because when you are sponsored by an employer, you have to go through two different phases. The first phase is with the Department of Labor, while the second phase is with USCIS. And employers must go through the Department of Labor and get approval there first to be able to apply and sponsor their immigrant worker through USCIS. Now, when you self-petition, the Department of Labor aspect is completely removed. And that means that it is a faster and shorter process because now the self-petitioner is able to apply directly with USCIS as opposed to showing that in testing the labor market. So it is faster and shorter, which is one of the biggest benefits. The second aspect is flexibility. With a lot of other temporary work visas or non-immigrant visas, it's very common and understood that those visas, they hinge upon the employer renewing the visa or work continuing. And a lot of individuals, especially who are looking to migrate permanently, as an immigrant, they want the flexibility of knowing that they're not tied to an employer or a job offer or having to rely on someone constantly. And when you're self-petitioning, you get your green card and you have the flexibility to move around to as many and different jobs as you want without having to go back to USCIS or do all of those other things that are associated with non-immigrant visas. And lastly, which I kind of mentioned this already, is the independence and autonomy. When you self-petition for your own green card, that means that you are taking control over your case. And if you've received a non-immigrant visa that has required a sponsorship, you're aware that, especially if you're working with an attorney, or the whole sponsorship process as a whole is usually between the employer and USCIS. When you're self-petitioning, it allows you to directly apply, directly rely on yourself and your skills and your ability. And a lot of people prefer that as opposed to relying on their employer and ensuring that they're following the required steps and requirements that are necessary with the Department of Labor and USCIS. But yes, the biggest benefit is that independence and autonomy to move around to different jobs as you see fit, without needing to rely on your employer. So the first self-petition we're going to talk about is the EB-1A, and this is the green card of extraordinary ability and is not to be confused with exceptional ability. For USCIS, those are two different things. So the EB-1A extraordinary ability is specifically for individuals that have and can show extraordinary ability in the areas of science, arts, education, business, or athletics. And if you're someone who you've thought about the EB-1 and you're looking at these categories and saying you may not fit specifically into any of these, I would still consult a specialist or an attorney to ensure that you don't fit, because usually you do, typically under the big umbrella of business, if you can fulfill the other criteria. The second thing is that you must qualify for the EB-1A. And the first way to qualify is to demonstrate national or international acclaim and recognition in your field. This is usually evidenced by an award or some sort of national recognition of that same level. But that is not an issue if you do not have that. If you don't have a national or international award or recognition, you can still qualify for an EB-1A if you can meet 3 of the 10 criteria listed on the next slide. So the good thing, again, if you don't have a national or international award, you can meet 3 of these and still get an EB-1A and get that employment-based green card. And this is the list. We're just going to run through them and I'll explain them briefly. First is a lesser national or internationally recognized prize. That's where you may have awards that you've received from your job, and your job has more of a national or international presence, but it's not as high as maybe a prestigious international award, that's something you want to use here. Many people disqualify themselves. I always say, look at every award you have and allow your attorney to really sift through it and see which ones may qualify under this category. Second, we have membership in associations in the field. What USCIS is looking for is they want to see that you're part of associations that specifically are tied to your job and shows and proves that you're in that field. For example, if you're an engineer, you want to be part of an engineers association. And that's because the qualification to already get in is usually to be an engineer. And when you have that membership, it kind of shows USCIS that there is a level of prestige or skill that's already necessary to just be in your field. Next, publish material about you in professional or major trade publications or other major media. What USCIS is looking for in this category is they want to see that whether it is a news article on something you've worked on or an article that's your skill, your impact in the community. This can be online. This doesn't have to only be print. What they want to see is that you're being recognized. That is the core piece of this specific category. Next, evidence of judging the work of others. This can be individually or on a panel. For this category, don't think of it as something so grandiose and big as being on a nationally recognized panel. As long as you've judged the work of others and you can show that you had to utilize your skill. Let's say you're a nurse and you're reviewing or judging a college. I know there's not nursing competitions, but if there was a nursing competition or something of that nature, you would be utilizing your skills. And that's what they want to see as far as judging the work of others, that you're using your skill and your extraordinary ability to now judge and evaluate the work of others within your field. Next, evidence of commercial successes in performing arts. That's pretty self-explanatory. Then we have evidence of original contributions or major significance into your field. For this category, you can see things such as if you wrote a chapter or a couple parts or chapters, I guess, of a book, or if you wrote an educational book that was adopted by a college, a high school, different universities or programs, that's something that you could see. Or if you develop something that is now being used within your community of work, that's what they want to see with original contributions. With authorship, similar, they want to see scholarly articles or proof of your work in a professional manner. Next, we have evidence that your work has been displayed in artistic exhibitions or showcases. That's for people who are mainly following in that art category. Next, we have evidence of performing a leading or critical role in distinguished organizations. Now, if you are someone you've worked for a well-known company and you worked on a major project or something that really was major in a sense or critical to your organization's functions or their daily work, this is one area where you can meet that qualification by evidencing it by letters from employers attesting to the work and the role that you played in achieving a certain outcome. This can also connect when a company has received awards. If you're able to show proof that you were part of the critical piece in achieving that award, you could also meet that category. And lastly, commanding a higher salary or significant high financial compensation in relation to others in your field. And that's when you can show, okay, the typical lawyer, for example, let's say we made 60 and you're showing that you make 80 because of all of your certifications or what have you. That's how you really, that's how you really fall within that category. Next, the EB-2 NIW. This is everyone's favorite, and that's because it's broader and it's easier to get into this category. And the EB-2 NIW is the national interest waiver. And it's termed the national interest waiver is because you're able to bypass the labor certification process because your skills are of national interest and importance. And to qualify for this, first we have to qualify and then we have to meet 3 criteria. To simply qualify, what USCIS wants to see on its face is that you have a bachelor's that is followed by 5 years of qualifying work. And qualifying work just means that the work must be related to your field. So if you receive a finance degree, but you have 5 years of modeling, unless you were working on the financial aspect of modeling agencies, it will not qualify under that category. Another way to qualify is through an advanced degree. That's if you have a master's degree or higher. A lot of my potential clients have this confusion about advanced degree and bachelor's. You are qualifying under the same category of advanced degree. USCIS just allows a bachelor's plus 5 years to be the equivalent of an advanced degree. So if you have an advanced degree, that master's degree or higher, you do not need to prove 5 years of qualifying work. That is just another way to qualify for an advanced degree within this category. Next, we have meeting the requirements for exceptional ability. And that is a great way. And we're going to go over those on the next slide. It is a catch-all for people who, let's say you're an entrepreneur, you're not traditional professional where you may have not gone to school or you went through certifications. It's another way to still get a national interest waiver without qualifying with your degrees in education. And like with the EB-1, you have to meet at least 3. So for this criteria, it's a shorter list, but I find that a lot of clients are easily able to meet the 3 of these criteria. First, we have an official academic record. This can be a degree, diploma, certificate, or a similar award. A lot of non-traditional students are able to use their certifications to meet that qualification. So I really like this category. Next, we have letters from current or former employers documenting at least 10 years of full-time experience. This is a great category if you're an established entrepreneur, whether it is abroad, mainly it's abroad, but let's say you're in the US and you're in school and you have that extensive resume from before or while you're in the US, then you want to use that because you can also qualify right there. Next, a license to practice your profession or certification. This is one what I really like that a lot of practitioners do. You're able to double up and sometimes use for this criteria to also meet this. There's no rule with USCIS that you can't use evidence, the same evidence to meet multiple criteria, which I love, and I do it myself. So if you're someone and you find you're looking at exceptional ability and you have this, you likely will qualify here as well for a license to practice or some sort of certification if you're someone who has obtained multiple certifications in your field. Next, just like with the EB-1, if you have evidence of commanding a higher salary or other financial compensation for your work and services. Again, we have membership in professional associations. Then we have recognition of your achievements or significant contributions to your industry from your peers, government entities, professional or business organizations. I love this category because with the EB-1, how you sometimes will need that very high award. One way to fit into the exceptional ability is if you have awards that you received from your job showing most skilled, highest achieved overall. Those are ways to also meet within these categories, or even if you get awards through your professional organizations, there's a lot of ways to meet it. And that's why, which I love about the EB-2, we have this catch-all as a category that says other comparable evidence. Comparable evidence means anything that is even close to these categories that still shows that you have a level of exceptional ability. And I love that catch-all because it's not as hard as you think to meet it. So if you're someone who's thinking, I might qualify, definitely still come speak to us or someone about the EB-2 because there's definitely probably a way to slide into these categories because you only have to meet 3. Next, now after you have met the initial qualification, USCIS is going to evaluate whether or not you meet these 3 categories of the elements, and it's broken down into national importance and substantial merit. They're grouped together, but sometimes USCIS will split them in how they evaluate it if they find one to not be present. Second, we have well positioned, and then we have on balance, which to me really isn't an element, but we're about to go through all 3. So first, national importance and substantial merit. For this category, for national importance, USCIS wants to see what is the broader implication of your work. So they want to know on a large scale, how does your work impact the US? And even on a global scale, how does your work impact the world? Let's say you're a scientist and you're studying a certain form of some experiment that can change the way that, let's say, we process foods. That's something that would be on a national or global scale. So that's what we're looking at with that national importance. Remember, it needs to be the broad impact of your work. Substantial merit is when USCIS now narrows that viewpoint and looks at what is the specific endeavor, what is the specific work that you're doing, and how is it related to the national goal, but how is it beneficial for the United States specifically? And again, the broader implication of your work, and now we're looking very narrowly about what exactly do you do? What are your skills? Are they lacking in the United States? Is your skill set, is there a lack of minorities or immigrants in your field? That's the more narrow aspect that USCIS is looking at when they look at substantial merit. Next, well-positioned. Well-positioned is usually a very easy one to do as long as you've met that first criteria. For well-positioned, USCIS wants to see that, is this individual strong enough to actually further their endeavor? For example, if you are someone who states that you want to be a nurse and you're petitioning to be a nurse in the United States, but you have not become a nurse abroad or you haven't taken the NCLEX, it's going to be a harder showing of well-positioned because there's another hurdle. And I don't want that to be the biggest reason that you may think you're not well-positioned. There are different fields that require you, if you're someone who's outside the US, to actually physically be present in the United States in order to be able to test and get into your field. I know one field that's like this from my experience is physical therapy. As long as you can show you've done everything up through the point of being physically present, you can show that you're well positioned. So again, for well positioned, we want to see, does this individual have the ability to actually start working and furthering their work once they arrive in the United States or switch into this category? Last is the category of on balance. On balance is where USCIS actually evaluates all of the evidence that you've provided. So they look at your national importance, they look at substantial merit, well positioned, your degree, and they say, does this outweigh the need for you to have an employer and a job offer? Which is why I always stress to people that the first thing you want to look at is there a demand in your field? Because if there isn't a demand, they might say that on balance doesn't really shift in your favor. So when it comes to the EB-2, and especially with the EB-1, but with the EB-2, the more evidence, the better, but the quality of evidence is really going to matter to tip that scale over. So we want to see letters of recommendation or people really attesting to your skill, proof of work product. Those are the things that are really going to give you a strong case and show that on balance, you do not need to go through the labor certification process. And I know I'm throwing around labor certification process to remind you guys, labor certification process is that Department of Labor piece that department that employers must go through if they decide to sponsor an immigrant. So how to go from F1 to EB1 or EB2. So you can go from an F1 to an EB2 very easily. USCIS does not have any issue from you applying for an F1 to EB1 or an EB2. But there are three big things that I really want to hone in and give tips as to doing so. The first thing is leveraging multiple degrees. There are a lot of immigrants who are here that are on F1 and on second master's degrees or second bachelor's. They have two bachelors and they're onto a master's degree. You need to leverage those for your categories. So if you're on your second master's and you're working in a high demand field and you have proof of your skill, you could already be applying for that EB2. Or if you already have met 3 of the 10 criteria for the EB1, you could be doing that at that moment. Now, as far as getting prepared, if you're looking into the EB1 or EB2, if you're an F1 student, one of the biggest things you could do is get involved. You want to be doing internships. You want to be doing the CPT and the OPT. You want to get experience. You want to ask professors if you can help them, do co-ops, anything humanly possible, because those things are those tasks are going to allow you to check off those boxes as far as the EB1. And it can help you with the EB2 as well if you're someone trying to look into the exceptional ability category or even just gain more skills so that you have a stronger EB2. And again, like I said, leverage the OPT and CPT, write down your references, write down who you're working with in detail, and document the work that you're doing so that when it is time for you to try to obtain an employment-based green card, you are not in the position of having to think about who you were working with, ask for letters of recommendation, or feel uncomfortable reaching out to people about the work that you did, because you will have all of it already ready for you. Next, one of the biggest questions I get is, how can I go from TPS to an EB-1 or EB-2? There are three big things you have to be aware of. First of all, you can go from TPS to EB-1 or EB-2. The first thing we need to look at is, when did you receive your TPS and what status did you have prior to it? A lot of people receive TPS when they're children, so there's nothing you have to worry about as far, regarding unlawful presence. However, if you are someone who entered the United States, whether it was unlawfully, or you exceeded your status and now you were here unlawfully until you adjusted to TPS, you will need to tell your attorney what status you had before and how long the time was prior to you receiving TPS. And it's not because you can't receive an EB-1 or EB-2. The good thing about TPS and with DACA is that if you can get advanced parole and leave and enter, you now have a legal entry. So your unlawful presence won't matter because you have your last lawful entry. But it is really important to tell your attorney so that they're able to consider what may happen, because if you had a prior visa, let's say a B1, B2, and then you switch to TPS and now you're going EB-1 or EB-2, one thing that may come up at the adjustment process or even through consular process is the intent of your original visa. And yes, it may be questions, not a big deal. Usually your attorney can coach you and get you through that situation. It's not hard whatsoever, but it's something to be aware of. Next, lapses in status. It is important to always tell your attorney if there's a lapse in your TPS status and how long, just so that they're able to evaluate and let you know if you may need another entry or if there may be waivers that you'll need to overcome. Now, if you obtain over 180 days, and I've stated this, but just to hammer it in, if you've obtained over 180 days of unlawful presence but obtained TPS, you can adjust by using your TPS advanced parole to get a legal entry. However, if you've had a previous visa that you overstayed, it's to be noted that you may have issues at the interview process regarding the intent of your previous visa. And that's because if the intent was visiting, it's something that the officer is going to ask you, and you should be prepared to answer. But again, if you're working with a good, talented, or skilled attorney, they will prep you way beforehand on this. So it's nothing to be worried about, but I always think it is very good to allow TPS holders to know this from the start. Now, DACA to EB-1, EB-2, it is essentially the same thing. Now, with DACA, we want to see that if you received it while you were a child, it's not an issue again, because the unlawful presence under the age of 18 does not count. And then 6 months after, and 6 months after is only because of the 180-day rule. Now, prior status and lawful entry, again, you want to make sure that if you've had any prior statuses or unlawful entries, that you always disclose that so your attorney can evaluate that on a case-by-case basis. And next is lapses in status. If there's any lapse in status for any reason whatsoever, you have to tell your attorney so that they're able to calculate it and let you know if you need a new lawful entry or anything of that nature. Now, are those the only categories you can adjust from? No, absolutely not. I just know TPS and DACA are the big questions that mainly come up as far as adjusting to another form of status. However, you can adjust from other non-immigrant visa categories too, H-1Bs, Ls, L2, O1, you name it. As long as it's dual intent, you're able to adjust. You just want to be strategic about when you're adjusting, because these visas, just looking namely at the H-1B, L1, L2, O1, O2, those are dependent on an employer. So if you are trying to strategize to get a green card without your employer, you want to kind of overlap the time so that you can still utilize your non-immigrant visa and possibly get approved for your independent green card at the same time and then adjust. Next, what about J1 visas? Absolutely. You can definitely go from a J1 to an EB. However, if you're a J1 visa holder, the first thing you want to do is look at your visa and look to see if it says subject to 212E. 212E means that you are subject to the 2-year home residency requirement. But I don't want you to get sad thinking, oh man, that means I have to go home for 2 years. No, you don't. You can get a J1 visa waiver. And that it is a complicated process, but it can be done, where you have to reach out to your consulate and figure out what the requirements are for a no objection waiver. And once you receive that, you're able to get an approval and then now apply for the immigration benefit of your choice with USCIS. And that goes from J1 to any other category. Even if you want to go J1 to O, if it has subject to 212E, you always want to make sure you're getting that waiver first, because it is required. If you apply for any immigrant benefit while with 212E, it's going to get denied because you do need the waiver. So what does USCIS really evaluate when they're looking at these petitions? One, and this is a big one, a very, very big one that I stress to my clients, the quality of your references. And I'm not specifically talking about who they're coming from, the quality of what is written in your letters of recommendation. If you're going to go through a green card process, it is very important to stress to the people who are writing these recommendations the need for detail as to your skills, to your work, the population you serve. Because if we can't get a quality reference, it can affect your case. Even with a very strong case, sometimes it can be hard to overcome if your letters of recommendation are not good or if you only have a few. So one thing you always want to do is provide quality references. Next, the quality of the evidence as a whole. We want to make sure it's clear and legible. If you're talking about your work product, you don't want to just drop pictures of your work product in the petition and send it. You want to detail and explain it to USCIS, explain how it's connected to an end result. So quality of evidence is very important. And last, proof of ability, which I kind of touched on. But it's one thing to say, yes, I sell clothing. It's another to show these are my sales. This is the manufacturers that I work for. These are the positive reviews. That's what USCIS is looking for, is they want to see some evidence of your ability. It will not be enough to just say, I can do this. That's why the letters of recommendation are very crucial, because if you don't have, let's say, sketches or work product, the letters of recommendation are going to be the evidence. They're going to be the evidence piece that proves to your skill and your ability. So those are the biggest 3 things, no matter what kind of case you are filing for, that they're looking at. Now, processing times. The current processing times with USCIS, the EB-2 at the Nebraska Service Center is taking 9.5 months, and it's taking 10 months at the Texas Service Center, and the EB-1 is taking 16 months at Nebraska, and it is taking 18 months at the Texas Service Center. And it's a little longer, but again, remember with the EB-1 and EB-2, if you've attended my other webinars, or if you're not familiar with the EB-1 or EB-2, these are categories that can be premium processed. Premium process means that you are able to get an answer on your petition for the USCIS part. For the I-140, you can get an answer in 15 days. Is it expensive? Yes, it has gone up to now $2,805 to premium process. But the good thing is, let's say you file today, and 10 months from now, and let's say you're an EB-1 processing at Nebraska, 10 months from now, you decide to premium process. All we have to do is attach a new fee and send it in, and then they'll premium process your case, and we'll receive an answer within 15 days of receipt. So that is unfortunately the end of today's webinar. I'm super happy for everyone who was able to attend. It is a pleasure and an honor to be able to be able to share any immigration knowledge to the community. And as a thank you, we would like to give you guys a waiver of the consultation fee, of $200. So if you decide to book a consultation, use the code Eagan webinar in all caps when scheduling to waive that fee. However, if you do have any additional questions, you can contact me directly at hannah.whaley@eganimmigration.com. And that's if you have a short question and you're not really sure if you're ready for a consultation. I'm more than happy to respond to your email and let you know what your chances may be. And again, my email is hannah.whaley@eganimmigration.com, located down here. And that free code is Eagan webinar in all caps. And I know I saw this question early on, but the recording will be sent out via email. So if you missed part of it or if you're late, there's no reason to worry. It will be sent out and all this information will be there. But again, thank you so much for attending today's webinar. It has been a pleasure and I hope you guys enjoy the rest of your week.